I just wanted to talk to you about a case that came down just a few weeks ago, where the well-known coffee maker, Keurig Dr. Pepper, leading producer of single-serve brewing systems and specialty coffee in the US and Canada, filed suit in federal court in Massachusetts, claiming that one of its former VPs, Jamal Wilson, who was charged with responsibility for leading the company's strategy and development for existing Keurig Bureau product lines and next generation single serve hot beverages, after handing in his resignation on June 6, with an effective date of June 17, violated his non-compete and fiduciary duties to the company by downloading some of their proprietary, confidential, and perhaps trade secret information, including PowerPoint presentations pertaining to their product development plans and strategies, and then began working for a significant competitor of Keurig's, SharkNinja, on June 14th, before his employment with Keurig even ended. Although Wilson did turn over his company-issued computers and iPhone upon leaving Keurig, it appears that those devices had been wiped before he did so, which naturally alarmed Keurig, which led them to seek a TRO from the federal court in Massachusetts, including a court order directing both SharkNinja and Wilson to preserve all of their data and have it forensically examined by an expert, and further, for an order compelling SharkNinja and Wilson to abide by the terms of Wilson's non-compete and restrictive covenant, which would prevent either of them from using any Keurig confidential information, and theoretically would also prevent Wilson from working for SharkNinja until his non-compete expires about a year from now. Predictably, the defendants opposed Keurig's application, with one of the primary thrusts of their argument being that while they admit Wilson's working for them, he isn't working in a division that has anything to do with coffee. So in point of fact, Wilson isn't actively competing with Keurig at all. And the defendants have both taken active steps to make sure he doesn't dip his foot or step over the line into the coffee space. So here's the interesting part, at least from my perspective, which doesn't get talked about or written about nearly often enough. Rather than fighting to the death over the TRO application, the parties reached an agreement on the parameters of a TRO, a temporary restraining order, including provisions whereby Wilson would certify that he has and will continue to preserve any Keurig data in his possession, and that within 5 days he would make available to an independent computer forensic expert for imaging any devices capable of computing functions or storing electronic information that he had accessed since the time he resigned from Keurig. And that would be pursuant to a protocol that the parties would all agree upon in order to identify any potential confidential information or trade secrets belonging to Keurig that would be located on these devices. The TRO that they agreed upon also had a provision that would not allow Wilson to provide any services for SharkNinja whatsoever that are related to the coffee brewing products. Here's why this is so smart, at least from the defense perspective, in my view. Among other things, the former employers in circumstances like these often benefit from the bad optics of the former employee downloading information that, at least on the surface of things, appears to be confidential information, and they more often than not have significantly deeper pockets and greater financial resources than the ex-employee to fight over the TRO. Moreover, in a lot of these cases, the underlying restrictive covenant, the non-compete, has a provision whereby if the employer is deemed the prevailing party, which would mean that they get issued the TRO, that the court may be allowed to award them their attorney's fees that they incurred in enforcing the restrictive covenant. So what the defense can do, if they're smart, is to pick their battles wisely, particularly if the ex-employee really isn't competing with the former employer directly anyway. And here, by saying, hey, we'll make the devices available for your inspection, we're basically saying we've really got nothing to hide. So that at least can blunt some of the arguments about the bad optics that are the former employees typically suffering from right out of the gate. Thanks for listening and have a great day.